Welcome back to the Legal Alternative Podcast. To me, SamPawson, joined as ever by Nils. How are you, Nils?
I'm good, Sam. You?
Yeah, good. We're back in person. I think we've had two episodes off. I think, obviously you were a bit of a week from hell last week in terms of a court all week. And then the week before, I think we did remotely. So nice to be back in person, back on the pod. I think you're kicking us off this week.
It is, yeah. I must apologise because we were discussing off air how exciting your update is and how utterly dry mine is.
Dry but important.
It is important. Mm-hmm. It is important. It's in relation to modern slavery.
Yeah.
So there's been some collaboration with the Australian and Canadian governments, and I think particularly for our clients who have a multinational element, this will be helpful. But there's now an international reporting template to support discharging your modern slavery duties across all three jurisdictions, actually. So it's really helpful. And we do have both large clients and smaller clients. I can think of a couple of small clients of mine that have offices in Australia. That this may help. And the aim of this template is to streamline compliance, basically. So a single report that's aligned with the UK guidance and also accommodating the differences between the UK and Australian and Canadian jurisdictions. So it's released on the 30th of July by the Home Office. Relates to modern slavery, forced labour, child labour. And obviously there's reporting requirements in the UK surrounding those topics. For those that are listening and thinking this isn't something that crops up that often, it's surprisingly common. So it's not something that's unusual, but equally it's not something that happens every day or every week or indeed every month. So as a template designed to streamline compliance, there's overlapping obligations within these jurisdictions. So it hopefully reduces the administrative burden by enabling the prep of a single report that covers all three jurisdictions. You've still got to bear in mind that you've got to consult and comply with the UK legislation, or if you've got offices in Canada and Australia, as I say, that some of our clients do, you've got to make sure you're aware of those legislative requirements. This doesn't totally remove the burden from a business. In terms of the template, I've had a look. There's some just points to discuss. It groups things into 7 themes, so you can report on your organisational structure, your policies, your risk management process, how you do your due diligence, what your remedial measures are, what training you do, and how effective your assessment of your actions is. There's then what they call a proportionate risk-based reporting section, and that's split into 2 levels. So you've got category 1, that's the core level disclosure requirements, and you've got category 2, which is your enhanced disclosures to demonstrate what is described as progress, leadership, and continuous improvement in supply chain transparency. Can't get my words out today. I'm sure this is a template that's going to change, so we'll keep people up to date on the changes that happen to that. So pretty dry, but an important document to make things easier if you do have, in particular, a multinational faceted organisation.
I think the last point, often when I'm talking with clients about modern slavery, supply chain, that even if you yourself as an organisation don't meet the threshold of reporting and having to have a statement, often we're seeing a lot now, my clients, smaller clients who are part of a bigger supply chain, that they are required in order to do business with these larger organisations to still do their reporting on modern slavery. So again, I think even if you're a smaller company, you're dealing with overseas territories, I think this is obviously helpful. Helpful templates, helpful guidance, as always.
Absolutely.
Right. I think we're on to me. We were talking, Nils, and I'm dealing with a case in the tribunal. It's on sexual harassment, in essence. And I think our regular listeners will know that I wouldn't exactly describe myself as prudish, or that I couldn't kind of share bad practice and bad language. But I have to say this judgment in this case is the tests that and tests probably what I am willing to say on a podcast, because I shared the judgment with you this morning. And I think it's both for us, fairly long practice now, probably some of the more extreme language that we've come across in practice. I'll talk through the basic facts of the judgment. We'll put a link in the description with an actual link to the judgment. And I've got the judgment here today. So for once, I've got some paper with me. And I will share that link to the judgment, because for those who aren't particularly sensitive, it really is quite shocking, some of some of the language used. The case we're talking about is a case of Mr. Davis and White Dove Garages Limited. So we are in the world of a kind of car dealership. As the respondent, with perhaps unsurprisingly a group of male employees, and whilst in practice I've, as I say, seen lots of these kind of cases of what we'd have called kind of banter between male colleagues, this does kind of take it to the level. So basic facts of the case is that Mr. Davis had worked in the motor trade since the early 90s, started employment with the respondent on the 8th of April 2024. Employment terminated only 21 days later on the 29th of April 2024, due to what the company said, a breach of trust for filming colleagues, and the filming will come apparent. So facts of the case is, during his employment, the claimant was subjected to aggressive behaviour from his line manager, and also raised concerns about unwanted conduct relating to sexual nature, racism, misogynist language, homophobia, and what he calls an abhorrent tone that was all over the garage, which in his submissions amounted to an intimidating, hostile, degrading, humiliating environment, which, as you'll know, is the test of kind of a harassment case under the Equality Act. The facts then of the case revolve around some filming and some covert filming that the claimant does to demonstrate, obviously, this environment. And this is ultimately why he's dismissed for doing that. The company says, obviously, without the consent of people. I won't read the part that is filmed, because it, as I say, is incredibly coarse, and that's putting it politely. Language is, incredibly misogynistic, racist. But if anyone is interested, the key judgment is page 18 of the judgment, which I say we'll put a link in the description. But what the recording shows is really strong language, all the F's and C's you would imagine, reference to drug taking, reference to sexual nature, really misogynistic language used. And obviously he's taken a recording. The key in these terms of the case law and the law in the claim is, again, less than 2 years service, only someone who's been in there a year. Then obviously claims brought forward. So there's two major issues. Obviously the covert recording issue, and which I think we've both dealt with a lot of in practice, which generally is dealt with by the tribunal if that is prejudicial to either party, to not be allowed. Clearly, for the claimant not to be allowed this hearing, which is his key bit of evidence, would be. So general rules on covert recordings, ideally you shouldn't be taking them, but it's the same with disciplinary hearings. If they are usually admissible as evidence, which again it is here. So claim, probably unsurprisingly, succeeds in harassment. Again, it doesn't always matter that the employee knows, in terms of protected characteristics, whether he shares them. Obviously, the language used here is really abhorrent, and it's creating that hostile environment. So again, the law particularly not surprising, but it's just a real judgment I did want to flag for people's attention, because the real extremity of the language I did think was a thing of the past. This case, even more so with the new sexual harassment legislation that came in last October. Again, it's really shocking that it's still kind of going on. So that real reason to kind of highlight that. It's just not even kind of tolerated. So for the company acting for this, they obviously must be aware that this is going on. They've tried to dismiss someone essentially who is, because there's also kind of whistleblowing. I
was going to say, is that
issues here, where he's kind of blowing the whistle on that kind of behaviour as well. So judgment, as I say, not legally particularly interesting. The reasons for highlighting, again, just really to show that kind of extreme language and sadly not a thing of the past, and to therefore highlight cases like this to say this, this isn't a problem that is over exaggerated. It's still going on, and this is really kind of why the legislation is put in to protect that. Again, something to flag, and as I say, that judgment available to anyone. I don't know, Nils, any views from you?
Does it say who the representatives were in the white dove garages? So I don't want to be too unfair on either the respondent or the representatives. I just wonder
why this ever got here.
Yeah. If I only read the one page that you've flagged up for everybody. Doesn't say the reps, I don't think, but he was a representative person as well. So he's obviously been quite brave, really. He's gone up against council. But ultimately, I would be looking at this if I was that business owner thinking, we're now talking about it. The adverse publicity from this is going to be really damaging.
Well, even if you win, how that shows the light of day in terms of a tribunal, I'm shocked. Even if you, as you said, even if you won on a technicality, even if you won on less than 2 years, couldn't to unfair dismissal because of whistleblowing or harassment, it's something you just don't want. You just don't want out there. Maybe they don't feel it is inappropriate.
Was there an award for damages? Do we know what that was? Or
I think, just let me check my notes. I think it may have been listed for a
remedy.
Listed for remedy. So
I mean, that is incredible. I have never read. I've read some bad language before, but that is, as you say, next level. A lesson for everyone.
Strong lesson for everyone, and it's job's not done. So I think I'm sure none of our clients, hopefully, and listeners have these sort of problems. I'm sure they do. There are still instances that go on probably at a lower level, and it's just try and keep that message. We go into a lot of manufacturing environments where much lower levels of this goes on. Again, it's perhaps a judgment to share with members of staff if you ever want to highlight that this isn't just kind of things that are being pushed as kind of wokeism. It's that's a real example of that. So always helpful to highlight, I think.
Absolutely. Interesting, very interesting.
Yeah, and moves us on to out the office. Tomorrow we'll be out of the country as well as out of the office, so a bit of a weekend late birthday trip to Ibiza, which should be fun. You've been celebrating some things as well
this weekend. So this weekend will be 20 years since I started university in Newcastle. Had much more hair then. So looking forward to that. Looking forward to catching up with some friends, some of whom I haven't actually seen since university.
Since 20 years.
So looking forward to that, and I'm sure it'll be a good do.
Neither of us can be there because of our involvements, but as always, sporting updates on the Rhinos have their big game against Saints as of the time of recording. Will have been Saturday, so fingers crossed for Leeds in the playoffs,
and Wakefield as well in the playoffs. Way at Lee, I think.
Way at Lee. So
everyone doing well.
Yep. So all good on the sporting front. It's lovely to be back in person, but we'll be back next week post weekends. So with some more updates. So thank you for me.
And from me.